Welcome, everyone, and thanks for joining us this evening. Tonight's class will focus on the 2025 legislative initiatives of the Delaware Office of Defense Services. I'm pleased to introduce our guest speaker, Alanna Mozeik. Alanna is a Delaware native and serves as the legislative director at the Delaware Office of Defense Services, working with the General Assembly and other stakeholders to advocate for evidence-based legislative improvements in Delaware's criminal legal system. After completing her undergraduate education in women's and gender studies and public policy at the University of Delaware, she worked on a gubernatorial campaign and as a legislative assistant in then Governor John Carney's office. Alanna moved on to the Delaware Division of Public Health, where she supported key legislative initiatives, including those in oral health access, reproductive and maternal health care, environmental justice, and communicable disease prevention and animal welfare. Shortly after joining the Office of Defense Services, Alanna completed her master's in public health at Johns Hopkins University in 2024. Her approach to legislative advocacy for ODS is keenly informed by her public health background and the importance of meeting people's basic needs to prevent criminal legal involvement. So welcome, Alanna. Thank you so much for joining us.
Thank you, Lynn. And I guess I don't really need to introduce myself, but I am really glad to be here. Thank you for inviting me, Lynn. And to those of you who are going to watch on the recording, hello. Sorry we missed you. Yeah, like Lynn said, I'm the legislative director for the Office of Defense Services here in Delaware. I've had this role for about a year and a half. So and as you heard, I don't have a criminal justice background. So I try to use my policy experience and my public health experience to inform my interactions with the legislature on behalf of our office. So we are basically the public defender's office. If you have never heard of the Office of Defense Services, we are formerly known as the Public Defender's Office. So I am gonna share my screen here. I'll get on with my presentation. I believe that you all have heard from some of my colleagues, Kevin O'Connell, who's our chief defender, and Misty Siemens, who was an assistant public defender in our office in our family court unit, but now she has moved on to Governor Meyer's office as his deputy legal counsel. So hopefully some of the things that I talk about won't be totally new to all of you. I'll try to describe them in enough detail that if you've heard it before, you won't be bored, but if you haven't heard it, then you'll know what I'm talking about. And feel free to stop me at any time if you have questions, and of course, I'll gladly answer questions after the presentation as well. So just a quick overview of our office. We offer high quality legal representation for people who have been accused with crimes and can't afford to hire an attorney. We have over 75 full-time attorneys. Oh my goodness, my cats are fighting behind me. Great timing. We have a staff of legal assistants, interpreters, criminal investigators, forensic nurses, mitigation specialists, client advocates. We employ experts to help with psychological or medical evaluations. We represent anyone who has committed a crime who can't afford an attorney, anywhere along the spectrum from petty theft to first-degree murder. We will represent you if you can't afford an attorney. But that representation happens both inside and outside the courtroom. So our office takes a holistic approach to criminal defense, and a collaborative approach as well. We center the client in our work. We don't do anything without the full consent and knowledge of our clients. But we also work to alleviate some of the underlying issues that a client may be experiencing in their life, whether that's food or housing insecurity, medical care access, mental health access, substance use treatment, other needed social services. We handle appeals, we handle post-disposition matters. So if somebody is looking for an expungement, we will provide guidance on how to achieve that. And we also prioritize legislative advocacy, which is where I come in. We want to ensure that Delawareans' rights are protected when laws are being created at the very beginning. And that is where I come in. So my job, before I even jump into our legislative agenda, my job is to work with our legislature here in Delaware to identify ways to improve our criminal legal system. And not everybody agrees on how to do that. A lot of times, the Department of Justice and my office will be on opposite sides of a discussion, of a specific policy initiative. And my job is to help provide information to legislators so that they can make an educated decision on whatever bill may be before them. So sometimes our office will identify bills that, or identify issues within the criminal legal system, repeated issues that our clients are facing. The attorneys or support staff that are identifying those issues will come to me and say, hey, I see this happening pretty frequently. Is there anything we can do through legislation that could improve this? And so our office will draft a bill, draft resources, information. We will collect data to try to prove our point, and we can bring that to the legislature, and hopefully they will take that and introduce it as a bill. And hopefully you all know how a bill becomes a law if you watch Schoolhouse Rock like I did. But a lot of times bills happen without our input. So the bill development will happen without our input. So another advocacy organization, a different state agency, a legislator who has gotten complaints from a constituent, all of those bills eventually get introduced, and I have to make sure that I have an eye on all of them and identify where it might impact our office, or more specifically, our clients. And so I will either work behind the scenes to try to contact the sponsor of that legislation. If it's something that we don't like, we will try to offer suggestions on how to improve it. If it's something that we do like, we will, of course, offer our support. So that support can often, or opposition can come through testimony in committee, providing public comment on behalf of the office. So I will do that, or some of my other colleagues if they are subject matter experts. And it's, I'm not an attorney, so some things are definitely beyond my expertise. And we work really hard to be reliable experts that the legislature can rely on. We want to be approachable, accessible, and that's part of my job. So I am in Legislative Hall almost every day, even if there's not a bill related to our agenda or to our office, I'll still be in Legislative Hall just to have that visibility and to make sure that legislators know that I'm available, our office is available, and we are paying attention. So I will get into our legislative agenda here, and these are our kind of our top priorities. We have a lot of little other bills that we work on, either again that legislators bring to us or smaller issues that we find, but these are the big ones. I didn't want to take up everybody's time for hours and hours. So the first I'll go over, and Kevin O'Connell may have talked about this when he spoke with this group, but death penalty repeal is a huge, huge priority for our office. And you might say, didn't we do that last year? We did. We repealed the death penalty last year. That was HB 70. It was a huge moment. I was very grateful to even be a part of it, but with the knowledge that it came from decades of work before I even entered this world, let alone the criminal justice space. So the bill that passed last year was a statutory repeal, and that means when you look up Delaware laws, the law that gives the Division of Public Health the authority to regulate drinking water is in the same book as where the death penalty was listed in the statute. So we removed all the language related to the death penalty from that Delaware code. But we are pushing for a second step. And that second step would be a constitutional amendment that would enshrine the prohibition of the death penalty in our Constitution to ensure that it never comes back. From our perspective, this is a firewall. Constitutional amendments are difficult to pass intentionally. So you'll see on the screen here, it says first leg. That's because we have to pass this twice. So if we're lucky enough to have it pass this year, then our next opportunity to have the same bill pass will be in 2 years when there is a new General Assembly. So after the next election in 2026, we will have the opportunity to pass this again. And so why is this important? Why do we want to have this firewall? Delaware has had a very long and dysfunctional history of allowing the reactionary politics of the time to govern our use of the death penalty as a punishment. We have gone back and forth, codifying the death penalty. The courts overturn it to say it's unconstitutional. We codify it again differently, unconstitutional, back and forth and back and forth. And over all that time, people have been put to death under unconstitutional laws, which, regardless of how you feel about the death penalty itself, we need to ensure that our laws are constitutional. And from what death penalty experts have been able to identify, there is no way to make a death penalty constitutional. So we are pushing very hard for this bill to pass. It's HB 35. I'm also happy to, Lynn has my contact information. So if anybody has questions or wants resources shared after the fact, I'm glad to send those. I'll pause there if there are any questions. Okay. Oh, Maria, hit me.
So my question is, from what you were saying before, that although you've removed the language from this statutory book, basically people are still up for the death penalty.
No, so that's actually a good clarifying question. I'm glad you asked that because it can be very confusing. So the brief history, the most recent death penalty law that we had on the books that we just kicked to the wayside last year, that was deemed unconstitutional in 2016. So as of 2016, Delaware has not been able to put anybody to death. So really what that repeal bill was last year was a cleanup bill because we were taking out unconstitutional language from the Delaware Code. It didn't need to be there anymore. Obviously, there's more weight to it than that. That's why we're taking that next step to make sure that we can't just pass another bill to put new language back in to the code. Does that make more sense?
Yeah, so another quick question, if this makes any sense, then why is it that the courts keep saying that what you're coming up with is unconstitutional? What is the barrier?
That is an amazing question that I would love to have a constitutional legal expert explain to me, let alone to this group. I think there have been different reasons. I have some notes up here. The most recent unconstitutional ruling found that judges making the final decision to put somebody to death violates the Sixth Amendment right to a jury trial. So that, that's just one example. I'm happy, Maria, to share a document with you that kind of details the back and forth. I can share that with Lynn after this because it is very interesting. There have always just been very varied legal challenges to all of these death penalty laws across the country, not just Delaware's.
Okay, I'm sure it's complicated. Thank you so much.
Of course. All right. So next on our agenda, and I know that Misty Siemens talked to you about police reform, specifically that second one on the list, but I'm gonna wait to get to that one. So because our office represents indigent people, people who can't afford an attorney, and a lot of those folks are Black and brown. A lot of them are, all of them are impoverished in some way. They can't afford an attorney to defend them in court. We often find that there have been negative interactions with police. And because of that, our office has taken the stance that we need to do everything in our power to ensure that the laws that exist around police conduct, police discretion, police, ability to pull somebody over, has very, very strict, narrow parameters, because we want to make sure that people are safe. We don't want to see people being killed by the police who are unarmed. That's not how our justice system should work. So the first on our list for police reform is a driving equality bill. And we are borrowing this from the city of Philadelphia. I always like to say that good public policy never worries about plagiarism. There's no need to reinvent the wheel. If somebody has figured out a good policy, there is no reason why you can't take that and adapt it to your own state, your own city, whatever, wherever you may be. So our intent is to reduce negative interactions between police and community members by reducing pretextual stops. And pretextual stops are often described as, pulling somebody over because they have a tail light out, but really the police officer is seeing that tail light out and saying, that car looks suspicious. It's old, it's run down. They might have drugs and guns in that car. And they may, but they may not. And rather than establishing some sort of cause for pulling them over for drugs or guns or suspicion of drugs and guns, they'll pull them over for the broken taillight. And they will, search the car through the windows, because anything that you can see through the window of a car is fair game. And oftentimes these traffic stops become escalated. So whether it's a physical escalation that results in injury or death, either on the person who's been pulled over or on the police officer, or even just increases in charges. So the police officer pulled this person over for a taillight out, but they smell marijuana on them. And I realize that it's complicated now that marijuana is legal, but now they're going to be charged with possession of marijuana, and it's just going to bring this person into the criminal justice system when they really didn't need to be. So City of Philadelphia passed an ordinance that prevented police from pulling people over for traffic-related offenses that were more specific to equipment violations. So that taillight out, the light above your license plate. I didn't even know that those existed until I got my car inspected, and they were like, your license plate light is out. And I was like, I don't even know what you're talking about. But I could have gotten pulled over for that. And it doesn't prevent police officers from pulling somebody over for genuine safety issues. And so we're still working with our bill sponsor on this bill to identify what we really need. We're trying to figure out where the existing data that exists around traffic stops in Delaware right now, where that is pointing us to, situations where people are getting pulled over for sillier reasons rather than safety reasons. The second police reform bill is what Misty, I'm sure, talked to all of you about. This is access to unsubstantiated police misconduct records. So our goal is to ensure that criminal defense attorneys, like the folks in my office, have the same access to police misconduct records as civil lawyers already have. So it's establishing parity, but why is this important, right? In many cases, I'm sorry, let me rephrase. In every case of suspected police misconduct, if somebody has called to say, hey, Officer Smith did X, Y, and Z, it's the police organizations that are investigating that complaint and either establishing that complaint as being substantiated, it happened, yes, it sure did happen, or unsubstantiated. Nope, we couldn't identify that actually happened the way that this person complaining about it said it happened. And that's not great, right? Like, we don't want the police to have exclusive ability to substantiate police misconduct. So if we have to operate under that system the way that it is, we want to make sure that our defense attorneys can access records that have been unsubstantiated, because there could be patterns there that could help our client's case. So if you have a police officer that has, 8 instances, eight complaints of lying on the stand at trial, and all of those have been unsubstantiated, it's important for a defense attorney to know that that police officer that has all these complaints, who's going to be on the stand testifying against their client, has this record of potentially lying. It's important for us to know. Now, this bill is going to be extremely contentious. We've had a fraught history of police reform in Delaware. I am hopeful that we can make some progress on this year, but don't be surprised if Lynn asks me to speak again next year and this bill is still on my list. We're playing the long game, and that's how legislative reform usually works. And the third one on our police reform list is mandatory juvenile civil citation. And this is a really amazing program. It's a pre-arrest diversionary program. So if there's a kid, somebody under 18, who commits a very low-level misdemeanor offense, petty shoplifting, jaywalking, that sort of thing, rather than arresting them and sending them to court, to family court, and having a permanent record that, down the line they might be able to go get expunged, but for now they're going to have a record. Police officers can say, I'm actually going to send you to the children's department through the civil citation program, and you're going to get assigned to a caseworker, and you might have to do some sort of non-monetary restitution. So you may have to write a letter to the person that you stole from to say, I'm really sorry, here's what I learned. And this program has seen amazing results. The kids that go through it don't recidivate. The kids that aren't sent through the program, their charges are usually dropped in court, but they still have that arrest on their record, which isn't great. So we want to have a list of charges that offenses that a child could be charged with that are mandatory for police officers to refer to this juvenile civil citation program. Because what we're seeing is that this program is not being applied fairly across police departments that are in some of our more urban areas, like the city of Wilmington, city of Dover. They're not using this as much as they should be. And in those cases that we've tracked, the kids' charges have been dropped anyway once they hit court. So they really would have benefited from using this civil citation program. I'll pause there again. Questions about police reform?
I have a question for you. Oh, I see Maria's hand is up. I'll let her go first.
So explain again. I wanted to be sure. So when the adolescent does get charged by the police officer for whatever misdemeanor, what exactly happens to that young person?
Through the civil citation program, or if they're not?
No, without being in your program, right?
So if the kid actually gets arrested, they are required to go to court and they will be assigned a public defender. Every child in Delaware under 18, regardless of their ability to pay. Now they don't have to take a public defender, but regardless of their ability to pay, they are offered a public defender. That's to say they could hire private counsel. But we go through a regular, often trial. Sometimes we will fight for a plea if that's, you know, an appropriate course. But as I indicated, a lot of these cases are being dropped or dismissed. So the judge is looking at it and saying, this is, honestly, this is kind of BS. We're just going to dismiss this one.
But however, that's still a record.
Correct. Yeah. So the
That's
arrest.
still a record. And
Yep.
that record speaks loads against that child into perpetuity, correct?
Yep. Correct. So
That
even
would
though
have
next
to
to
be
that record, it'll
expunged.
say, you know, case dropped, there's still that, you know, maybe it's more of a gray line instead of a black line, but a gray line that says I was arrested when I was 16 for stealing chapstick.
That's right. So it's still
Yeah.
a public record, and it's still something that when I go to employment, I have to say I was arrested.
Correct. So that's why the civil citation program is so great, because it keeps it in the civil side. They don't touch the criminal justice system. So there's no criminal record. They get access. Not only do they get access to this caseworker for, you know, the restitution or it's honestly more rehabilitative. So if this kid, you know, is missing resources like food access or medical access or transportation access, that caseworker at the children's department will help connect them. So it is a more holistic look at, like, why did this kid do what they did, or why were they in this situation, and how can we work to prevent it? So it's a really successful program.
So in your case, in your program, if they're placed in it, they still have a charge?
No. Nope.
No. Okay.
No charge.
But they do have to go to court.
They do not. They don't have to
They
go. So
do
the
not.
only way that
Okay.
they would end up going to court is if they failed to complete the program.
Okay.
Off the top of my head, I don't have the numbers on the amount of kids that don't successfully complete the program, but it is very, very low.
I don't understand why any adolescent isn't in your program. That's what I would
I'm
like
with
to
you.
see.
That's why we're making, that's why
Thank
we want to
you.
make it mandatory.
Thank you. Thank you. Okay. Thank you very much.
Absolutely. Thanks for the questions. Lynn, you had a question too?
Yeah, I have a question about the driving equality.
Yeah.
Just everyone understands. So, the person with the taillight out is no longer going to be stopped because that leads to potential escalation and bad outcomes. But the part that you didn't say is what happens. Doesn't that person still, aren't they going to get a citation or a letter in the mail that says, hey, your taillight was out? Or no?
Potentially, we haven't figured those details out yet. A lot of that is going to depend on the conversations that we'll end up having with law enforcement. Because in my experience, law enforcement does not like when you take away these, what they feel is their right to make these decisions about pulling somebody over. And really, we just want to build in protections for both the driver and the officer. So to answer your question, Lynn, that may be how it ends up happening if our integrated, you know, law enforcement system has the capability to, you know, send out a warning to the owner of that car, where it, you know, will populate a letter gets mailed to their house, almost like a red light camera, honestly, where it says, you know, we caught you going through this red light. Really, it's, we caught you with a taillight out. Here's your first warning. Get your taillight fixed. That's not what Philadelphia did. Philadelphia just did a blanket. You can't pull people over for this. If there's somebody with a taillight out who's going 50 in a 25, you can pull them over and then also say, hey, fix your taillight in Philadelphia. But really, you're pulling them over for the unsafe speed rather than the taillight. So TBD is the answer to your question.
Okay, thank you.
Of course. Anybody else? No? I'm gonna take a quick sip of water. So one of the other big bills that we've been working on that I am excited about is compassionate release. And in Delaware right now, there is a provision in our law that allows the Department of Correction to identify people who are incarcerated that they feel have a serious illness or infirmity, who they feel have been rehabilitated, and who they feel should have their sentence modified. So this person may have a really lengthy sentence, they may still have years and years left to serve in prison, but the Department of Correction can say, you should be let go. You should be released into the community. And that application will go to the Board of Parole, and the Board of Parole will review it, and they may say, we agree with you, Department of Correction, and they'll send that on to Superior Court, and a judge will review it. And a judge may or may not say, I agree with everybody before me. You should have your sentence modified. And so they'll put the green stamp on it, and the person's sentence will be modified. The problem with that is multifaceted. Number one, the Department of Correction is the only one who can identify these people and initiate the process. Number two, there is no definition of serious medical illness or infirmity in our statute, in our laws. So the Department of Correction can say that anything they want about the severity of somebody's illness. I could go on about the issues, but really our goal here is to expand the eligibility of people who are incarcerated in Delaware to access this sentence modification process, either because they are very, very sick and deserve the dignity of dying with their family members surrounding them rather than in a prison, or that they've been in prison for a long, long time and they're very old, and having them stay in prison is no longer rehabilitative. Like they have done everything that they could possibly do to rehabilitate themselves, and is now more punitive. Like you are just sitting in prison to sit in prison. And so we wanted to establish a new process for these applications so that the Department of Correction isn't the only one to initiate that process. Because even if the Department of Correction is a perfect model of, rehabilitation, what have you, there is always going to be speculation that they are not doing what they could do for people in their care. So we want to take some of that burden away from the Department of Correction. We want to ensure that a person is offered an attorney through my office to help them through this application. And we also want to streamline the process. So we're taking the Board of Parole out. Parole was abolished in 1990 with Truth in Sentencing, maybe before that. I can't remember exactly when Truth in Sentencing passed. We have very few people left who are parole eligible. This sentence modification process is just one extraneous thing keeping the Board of Parole alive when it will soon die a well-lived death once nobody is parole eligible anymore, which I'm sure is in the next 10, 15, 20 years. So this is a very, very big bill. It is going to cost a lot of money. I don't know if it's within the state's budget this year to pass this bill. Department of Correction is going to need resources. My office will need resources. Department of Justice, the courts. But it is something that's very important to our office. We're pushing very hard for it. So I'll pause there again for questions.
Sure. What makes it so expensive? I mean, on the one hand, the state will no longer be paying to have that person incarcerated. So, and yes, there will be some new legal costs that are outlined there. what other expenses add to that cost?
Thank you, Lynn. The legal counsel is definitely the biggest cost. We don't currently process these applications, so our office will need additional attorneys and support staff to be able to process these and support folks through this process. I think the one thing that our state really does poorly is being able to calculate a cost savings through this. And one thing that I'll also address, even though you didn't ask it, Lynn, is, are we just going to be kicking people out on the street to die? And that's something that I've wrestled with personally, especially with a public health background. And I've spoken with people who have served time in Delaware prisons, and they reminded me that this will largely be, this isn't going to happen in a vacuum. This isn't going to happen to the person that's incarcerated. They will be an active participant as much as they can be if they are seriously ill. In many cases, they'll have a family member that's working with an attorney to advocate for them. But beyond that, this process isn't a guarantee. So a judge can still look at somebody's application and say, you are terminally ill. You are going to die in the next 2 months. You don't have a place to go. There is, let's say they committed a sex offense and a long-term care facility is not going to take them because they have restrictions about people with criminal backgrounds and people who might be on the sex offender registry. You don't have any family to take you. You have, like, you're receiving hospice in Department of Correction. You're receiving care here. I'm not going to modify your sentence. And so I think that there's kind of two sides to that coin, right? Like, there might be somebody who does have that support system in place, and it will be their choice to go apply for this and try to achieve the sentence modification so that they can go home to their family. And there are going to be some people who say, I have nothing outside of prison. I've been in prison for 50 years. I am not in contact with my family anymore. I'm okay to die here. And so that was something that we considered very deeply as we were drafting this, to ensure that things are happening with the consent of the person, so that it's not happening to them.
Maria?
So Alanna, I was thinking the same thing about the costs. Have you been able to go to another state that may be doing already some compassionate release and see what their cost estimates? I mean, am I wrong? It costs about $50,000 a year to keep somebody incarcerated. Maybe
Probably
more
more than
today.
that.
Probably
Yeah,
more today,
it's,
right? That was
yeah,
a long time ago.
The Department of Correction won't give you a direct answer, and this is nothing against them, but they won't give you a direct answer if you ask them how much it costs to house somebody.
You're very kind. It is against them. I'm sorry. I think this thing about we don't have data in Delaware, and because we don't have systems, that's been an excuse for so long. On the other hand, when you try to pass a law, the first thing they ask you is, how much is it going to cost?
Absolutely.
But they can't give it to you. They can't give it to you. So I think that's wrong. I think you need to fight that battle. But
we definitely try.
But I agree with
think,
you that, yeah, go ahead, Lana.
Oh no, I was just going to say, I'm mindful that this is recorded and I am working with the Department of Correction on this bill, so I want to make sure that I stay on their good side. I'm just teasing. No, they actually, the Department of Correction has actually been a very good partner through the development of this bill.
Okay.
Even though they haven't given us a direct answer. And truthfully, I don't think they know. I think that it's so varied person to person on how much it costs to house somebody. I'm sure they could calculate an average, but they're going to be outliers, especially with people who are, sick and using medical care. But I think the important thing to remember is, even with those folks that are sick, if they get out of prison, they're most likely going to be on Medicare or Medicaid. So they're still going to be using some sort of public assistance for their health care. And so in the end, I don't know that it would be that much of a cost savings from a medical perspective, just because we know that given everything surrounding people who are re-entering society after they've spent time in prison. It's hard to get even if it's for rehabilitation and not for serious illness. You know, if they're trying to get a job, they're gonna have a hard time getting a job because they have a criminal record. They're gonna be barred from Section 8 housing because they have a record. So because of all those things stacked against them, I don't know that it would actually be that much of a cost savings.
So without, have you considered that, again, we're waiting too long to come into a compassionate care release? And is there something about, you know, if you've served 25 years, is there time to consider release on those people, even though
So
they're not
that's actually,
terminally ill?
yeah, no, I'm glad you asked that. That is part of this bill. So we sort of have three buckets in this
Okay.
bill. One is for people that are sick, and that could be any age. I am 30 and I could go to the doctor tomorrow and be diagnosed with a terminal condition, right? Like these diseases and conditions don't discriminate based on age. So nor are we with the illness or infirmity provision in this bill. But we're also looking at people that are older. So one of the buckets is people who are 60 and older and have served at least 15 years in prison, because we want to make sure that, I say we, some of the other stakeholders want to make sure that people who are 65 and have just committed their first offense aren't being evaluated for sentence modification on their 66th birthday when they've only been in prison for a year.
No, you've
So,
got to serve some time.
right,
I
and
understand.
we understand that. So the third bucket is people blanket, regardless of your age, that have been in prison for 25 years.
Thank you.
Yes, because 25 years is a long time to spend in prison. I'm a different person than I was 10 years ago. I
Right.
am sure all of you are different people in some ways than you were 25 years ago. And some of what I'll talk about, I think it might be the next slide or the slide after that, is addressing these long sentences, because they're not doing anything for public safety, really.
Well, and by the time these individuals are released, the problem that you're finding is that their children are old, their parents have died, their wife has moved away. There is no support system. There is no
Right.
community. I keep thinking of the movie Shawshank Redemption. You remember
Yes,
that?
I sure do. It's a great movie.
Shades of
And
Shawshank.
and
Yeah, and
now
so
what
they
people
got nowhere to
are
go.
and now what people are experiencing upon reentry is how much technology has changed.
Yes.
So there are folks 5 years ago that were released that had never even touched an iPhone, that, you know, used dial-up AOL the last time that they were in society and out of prison. So yeah, there are definitely challenges to this. And what I hope that the Department of Correction will ask for in terms of resources is reentry supports. I think they do as well as they can with reentry, and we have a lot of organizations outside of the state or within Delaware, but outside of state government, that provide reentry support and services, and they do an amazing job, but there's not enough of it. There's not enough of them, and our folks that are reentering society suffer because of it.
I still think some of the costs of some of the deferred costs of incarceration, there could be some funds set aside for support in entering a community again, especially for older people who just have nothing going for. Thanks.
I totally agree with you, Maria. Thank you so much. Anybody else have questions before I move on? All right. Oh, good. It was the next slide. So I mentioned that we have lengthy prison sentences. And a lot of this was based in the federal law that I mentioned before, which is truth in sentencing. People used to be really upset that somebody would be sentenced to prison for 10 years, but they'd get out after 3. And so truth in sentencing was supposed to ensure that people served their full prison time, so that full 10 years. And that's part of why parole was abolished in Delaware, because it didn't align with truth in sentencing. Because really, when you're on parole, you are still serving your prison sentence. You're just serving it outside of prison. And it's different from probation. Probation is supposed to be more of it should be like providing supports to people as they're re-entering society and ensuring that they still have some level of guidance or restrictions to help with that transition. I don't know that our probation system works all that well, but that's a conversation for another day, and one that Lynn and I have been rehashing over and over and over again over the past few weeks. That's not on my list today because I just couldn't do it. So anyway, SENTAC reform. So what is SENTAC? It's the Delaware Sentencing Accountability Commission. And so it's a board of, I think, like 17 people right now in its current format. It's judges, prosecutors, defense attorneys, Department of Correction, the police, lots of different people. And the goal of SENTAC is to provide guidelines on how people who've been convicted of crimes should be sentenced. So if you, and I want to be clear, I don't know, I work with a lot of attorneys who can remember recommended sentences for specific charges off the top of their head. That is not me. So I'm going to make stuff up and you can't quote me because I promise it's fake. So you'll have a, let's say a forgery. Let's go forgery. So somebody who's committed forgery, let's say it's a felony. I don't know if felony forgery exists. Don't quote me. But let's say that associated with that, there is a recommended sentence of 3 to 5 years. And that is a guideline provided by SENTAC. So the General Assembly will pass a law that says forgery is bad. We're going to make it illegal. It's going to be a Class G felony. And SENTAC will take that law and say, okay, we have a new crime. Let's provide guidelines for how somebody convicted of this crime will be sentenced. And they'll determine, what sort of victim might be associated with the crime, if it's a violent crime, and try to decide how much time in prison somebody should serve. Or sometimes not at all. Sometimes somebody will be convicted to 1 year of probation and won't serve any actual prison time. But SENTAC is a very unwieldy board. It does not work well together because there are a lot of people engaged in this commission that don't actually have anything to do with sentencing. So the Department of Correction serves on this commission, and they are housing somebody during their sentence, but they don't actually have anything to do with that person having committed the crime, the trial, what the sentence should, they're not providing input when the judge is trying to decide what the sentence should be. They're just the afterwards. They just handle whatever has been given. And it's the same with police officers on the front end. They've charged somebody with felony forgery, and they may participate in trial on behalf of the prosecution to say, yeah, I literally watched this person sign somebody else's name. They've committed forgery. But beyond that, they have no input into what that sentence may be. So the way that SENTAC currently exists has just way too many extraneous people. And we are focused on overhauling this membership to ensure that it's just limited to those actually involved in sentencing. And that is the prosecutor who is saying, this person committed forgery. We recommend the maximum 5 years for this Class G felony. And the defense who will say, okay, they may have committed forgery, because now this person's been convicted, but it's their first offense. So really they should have the minimum, which is 3 years. And the judge is the third. The judge makes the final decision on what that sentence is. And the judge can say, I agree with the defense, we'll do 3 years. The judge can say, I agree with the prosecution, we'll do 5 years. Or the judge can say, let's do an even 4 years. And so our goal is to have 3 judges, 3 prosecutors, and 3 defense attorneys on this commission, almost like a nerd squad of people that love criminal law and understand how sentencing works and what it means for the person who's being sentenced, and just making it more of a like loose board that can really dig down into what the issues are that they need to address. And the other thing that we want to do is establish an executive director position to manage this board. There's not a lot of state funding, and we don't expect the General Assembly to throw money towards CENTAC. But there are a lot of grant opportunities out there for states to conduct research into sentencing practices, research-based projects. And so we want an executive director not only to be able to manage the meetings and the topics that CENTAC will have, but also to identify those funding streams, and to bring resources to Delaware so that Delaware can be the forefront of sentencing rather than falling behind the pack. And this is a unicorn in the legislative world, or at least in the criminal justice world. My office, the Department of Justice, and the courts are all in alignment on this bill. That never happens. We are usually, one of us is fighting the other. Sometimes it's 2 against 1. So we are hopeful that we will have success with this bill. CENTAC reform has been tried before, but they've always, I think, gone too far with it, tried too much too quickly, and so those bills never passed. So we're trying to do a very streamlined version to streamline this commission. So again, I'll pause for questions.
I just wanted to say that this one makes sense.
Heck yeah. Thanks, Maria. All right. That's all I had for my presentation. I think I nailed it within an hour, and we still probably have time for more questions. If you have questions about the office, about the General Assembly, about me, about my cats that were fighting 45 minutes ago, I am here as a resource.
Well, and thank you to those who joined during the presentation. We didn't see you when we kicked off, but glad you're here now. Thank you. I'll throw out a question, just to give people a sense, when you have an ambitious agenda like that, that's a lot of bills, on your list. In a given session, and you can speak to either this one specifically or just a generic one,
Sure.
what do you generally expect in terms of progress on a portfolio of bills that you're trying to shepherd through?
That is an amazing question. It can be really difficult to identify performance in one specific General Assembly. And I apologize, my cat is crying for dinner because it's 8 p.m. And I think it's because these legislative agendas that agencies have don't happen in a vacuum. I would love to focus all of my time on these 6 or 7 bills that I've laid out for you. But I have to track 50 to 100 other bills that may impact our office or our clients that I have to research and put time into, either drafting public comment for a committee or even just writing an email to a legislator to say, this is a really bad idea and here's why. And so I'm And there are also bills, like all of these bills that pop up. Sometimes we're opposing them, sometimes we're supporting them, and sometimes we can take them also as a win, because it's not even about what I can achieve myself for the office. It's also like, has the General Assembly done a measurable level of improvement in the criminal legal system for our clients? So even if it's not my bill, and I talked about probation a little bit, the ACLU has spearheaded probation reform in this state, and my office has let them take the lead a little bit. We've provided technical support. We're in every meeting. We try to stay up to date on the conversations. We won't necessarily take that as like a ODS passed probation reform, because it hasn't been our primary effort, but we will take it as a win for our clients that hopefully when that bill passes, things will improve for folks that are on probation. So it's less about like, did this agenda get passed, and more about thinking about it in a broader way, that this, again, would love to just run these bills. The House dropped a list of legislation that they just introduced today, and I spent 2 hours looking through every single bill that they introduced, because sometimes it'll be unrelated to anything criminal justice, but there will be one line in there that's like creating a new felony. So I have to comb through every bill that's introduced. So I would love to take I would love all these bills to pass and to count them all as wins, but I know going into it that it's not going to happen in a year, in many cases, and I take all the help I can get.
Thank you for
You're
being
muted,
there,
Lynn.
Lana.
Thank you, Maria. And I think Sally had a question.
Yeah, I have one question. Thinking of when we at Westminster and friends could make input that might be helpful and might be supportive of legislation, it would be, is there some way we can sort of keep tabs on that, and when's the appropriate time to make input?
I defer to Lynn a little bit to answer that question. The legislative session is very fast paced. Session runs from January to June, and there are actually only like 45 days that the legislature meets within there. So they'll do 3 weeks on, 2 weeks off, 2 weeks on, 4 weeks off, and it's just a lot of back and forth. And so they don't schedule committee hearings with the full agenda. You don't have that until 4 or 5 days beforehand. So I don't know what the infrastructure is like with this group. If Lynn, if any of you or other folks are paying attention to agendas being posted and kind of disseminating information.
Right. So we do, in general, folks who are coming in to present about what they're advocating for, they're usually part of an organization that has a distribution list, and this is their opportunity to say, sign up to be on our mailing list. So you'll hear from us, whether it's the ACLU or DCJ or whatever, you sign up to be on their list, and then you'll hear when they have a call to action, like come out to give public comment on this, or sign this letter to your legislators or whatever. And so they're on a list to the call to action. ODS doesn't have such a list, but
Right.
you guys do communicate with this Coalition for Smart Justice.
Yeah.
And so the Coalition for Smart Justice is, as the name implies, a group that has, all these different organizations, working together and things. And I attend the coalition meetings in part as a liaison for Westminster's Peace and Justice Work Group. And so, yes, I am able to bring back to our group when opportunities come up. Bill Nace, who's part of our Peace and Justice Work Group, is also a pretty regular attendee at those Coalition for Smart Justice meetings. So we do have folks there. And so I guess one of the things we need to figure out is, you know, I don't want to fill up people's mailboxes with stuff, particularly if they've already signed up but are getting the DCJ newsletters and the ACLU's newsletter. So I don't know if I want to automatically send stuff out to everyone all the time. So we'll have to think about that, but certainly anyone on this Zoom that has a particular interest, I can certainly continue to forward stuff your way about these bills. And we can talk on an ongoing basis about what makes sense in terms of having our own internal call to action emails for criminal justice reform, because it is a hot topic with a lot of stuff happening.
Yeah.
Um,
Something like that would be helpful, because I for one, probably many people feel like I'm drowning in advocacy emails.
I hear you.
Um, so the ones from Westminster I would particularly pay attention to.
Well, maybe I'll commit to doing a, reach out to our Peace and Justice Work Group when there are specific calls to action in the criminal justice reform space.
That would be wonderful.
Yeah, and I'll try to consolidate those calls to action, whether it's coming from Alanna at ODS or DCJ, ACLU, or our campaign to end debtors prison, whoever it's coming from, and I can consolidate those calls to action and send them out. So I will add that to my to-do list to remember to do on a periodic basis.
Thank you, Lynn.
Sure. Any other
Trying to
final
stay
questions?
engaged despite the the deluge of emails. I do it for a living, and I'm still overwhelmed by all the advocacy emails I get. So I'm with you.
It's now well after 8. Any final comments or questions before we close out?
And Kat wanted to say hi. This is Freddie. He is also a proponent of criminal justice reform. So
He's a proponent of food.
that too. That too. He is reminding me what time it is.
Alanna,
He's saying that it's an injustice that I haven't fed him yet.
Thank you very much for taking your evening with us.
No,
We
it was a
a lot and
pleasure,
greatly
and-
appreciate it.
We
Thank
learned,
you.
we learned a lot. Thank
I'm
you.
so glad, and I'm
Thank you.
glad that you all felt comfortable to engage and ask questions. Lynn has my contact information. So if you have other questions, send them to Lynn. She can send them my way, and I'll be glad to provide answers to the best of my non-attorney ability.
Good job. Thank you.
Great.
Bye, everybody.
Thank you.
Take care,
Bye,
everybody.
everyone.
Thank you so
Good night,
much.
everybody.